An officer is dispatched to a Walgreens for a suspected shoplifting incident that should have ended with a routine citation or arrest. Instead, the situation escalates without warning. The suspect flees, resists, and turns violent during the struggle, biting the officer before disappearing into a nearby tree line. What begins as petty theft rapidly transforms into a high-risk pursuit, a medical emergency, and a case with serious felony consequences.
Where are you going? Stop! You're under arrest! Wait, 20, I'm out with the female at the Walgreens.
No, please. Please.
Stop her now!
Please, go.
Stop resisting!
Please, let me go.
You're under arrest
Please.
now.
Please let me go.
Oh, you're under arrest.
Please let go of my gun.
Oh, stop.
Please.
You are under
Please let me
arrest.
go. Please let go of my gun.
I'm not letting
Please
you
let go of my gun. Please.
Stop! You grab me?
Please let go of
You're
me.
going to jail.
Please.
You got nowhere to go back here. If I let go, I'm going to get you on the other side. Let go of me.
Please don't. Please.
My backup's
Please.
coming, and you're going to get tased.
Please don't.
Stop right now!
Please. Okay. All right.
Stop!
Okay.
Hands up now! Hands up, you're under arrest! You understand me?
Can't put my other hand up.
Nope! Put your hand up! It. 20 Walgreens. Ingalls and Larkin. Female bit me. She's in the wood, tree line here.
We got units around. 22 on my black and Larkin. Hold on, I'm almost there.
You're gonna get tased as soon as you get out of here. Give me a unit. Yeah, she's in there somewhere. Female white wearing a white hoodie.
Female white, blonde hair, white hoodie.
Ma'am, you are surrounded. You are under arrest. Come out with your hands up.
Oh, no! The canine is coming. You're gonna get bit. You better sound off right now. Get your hands up.
Come on out. I hear you. Hands up. You lost. You just made matters worse for yourself. Come on out. She's definitely in it. She didn't jump out. She wouldn't be able to jump out that fast.
1602,
That's where she jumped over, right there to your left. And she dunked down over here. Can we get a unit to the north side of the building? She dropped her purse. Probably has the merchandise in it, maybe an ID. You are under arrest. Come out with your hands up before you make it worse for yourself.
21 got bit, right?
I got it.
You got bit? Yeah. You just take your coat off in here just to make sure.
Lady bit me. Yeah.
Comes back to Samantha Bravado. Out of Bristol.
No, where'd you? Oh, wait, what's that?
Hey, Samantha, she should be 99.
She didn't break through her skin at all.
Right here.
Okay.
At the 2 marks
Yeah, she
there.
should be 99 in the county.
Yeah. She didn't even really break skin. Sarge said she's a
25 up to
prostitute.
23.
So
The
just
west
saying.
edge of
Oh, come on.
That's what he said. Yeah, she didn't break the skin, which is a
A
good thing.
little bit of blood, but
I would say, yeah, because that's disinfectant, so that would be your best shot right now, just to keep it clean, try and kill it. And then, yeah, the big thing is just, wash them, man.
they thought she was stealing. I was talking to them inside about some other case, and she just slides out, starts running. I'm like, well, that's good enough for me.
Yeah.
Just chased her, jumped over there.
So she's hiding out here somewhere?
Yeah, she's in there. You saw her jump this fence? She jumped right over here. I held on to her as long as I could, so she then she went, tried to get to the other side. I ran around, she never made it. And she tried to crawl and jump down, so she's laying down right here in the brush.
All right. Joliet Police K-9! Amanda! In the one line! You are
Units
under arrest! You are under arrest! Make yourself known right now! It's all for you to search! He will find you and he will fight you! Here! 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 Samantha, the dog's in there! Get your hands up! Get out! Got her?
All right.
Good job, guys.
First, before I go, I know I'm going to go to I can't go to the hospital.
Get on your toes. Get on your feet.
I'm trying.
Is she already crying for an ambulance?
Yes.
Yeah.
14 today, social best.
Well, they're gonna be good here. I'm gonna go and
the bag?
Yeah, I'll get the bag. I'll go get it.
There's her stuff.
Thanks. She bit me. So Yeah, that's all right.
Yeah.
They wanted you to show up even though I was in the.
Okay.
Yeah, I can't, like, I've dealt with her, but, yeah.
Can you get him to do a show up?
Yeah. I'm gonna do it, though.
Okay.
In the car.
Alright.
You alright?
Yeah, she barely cut the skin.
Yeah, she saw you and she just took off a bit, right?
I tried leaning in to see if I could see anything. I couldn't see anything. You guys didn't have her anything. I didn't have anything. And so, can you just see what is yours?
Yeah.
I'll get a property theft log.
52 come to the rear of Walgreens.
You want me to at least handle the retail theft portion and you just handle the, like...
No, it'll be all together, so.
You okay?
Yeah, can you grab me a retail theft?
By the way, we're headed over there now.
That's not you. What's up, man? You good?
Yeah, go ahead.
Yeah,
I want to see.
barely broke the skin.
Yeah, you probably gotta look. Still gotta look at it. Dirty.
They looked at it and said, just clean it up and that's all I need.
Okay.
And then they documented for whatever on a report, just...
All right, as long as you're good with that, now we can get you some swing up there. Okay.
Okay.
What was she stealing? Was that the problem?
Yeah,
Okay.
so I came in here to talk about a different case, see if they had video from a different case. They told me, hey, good timing, this lady, her purse is getting larger and larger and larger.
Sure.
They didn't see anything taken for sure, so I stood by the register, figured I'd deter, tried peeking in her purse as she was trying to check out a few items she had.
She didn't agree with that?
Then she just slid and then
Gotcha.
just booked
Okay.
it. So I took chase.
As long as you guys are good. Well, I'll see you guys down at the station then, just whenever you're done.
Alright.
Oh, my goodness.
Right place at the right time, or
Yeah.
the wrong place at the wrong time.
When's the last time this dude chased somebody out, got bit?
Oh, no.
She literally gave me a fake, like, she gave me a fake name, right? But, like, when I walked up to her, I was like, hey, what's going on? Samantha? Like, that's not my name. I'm like, oh, I'm so sorry. I genuinely felt bad because I thought I called her the wrong name. And then later on, I'm like, you asshole. Like, you had me really thinking that I called you out your name. She's like, I know more. Like, that was so stupid. Like lie to him. He's never met you.
Yeah.
I think giant rocks or something crazy. So this is all we're looking at pretty much. Is this yours or is this yours?
No, that's hers. And then, yeah, she actually bought that.
Did she buy it? 'Cause
Yeah,
she was in the process.
Yeah, she bought that.
Oh, at the pharmacy.
Yeah, and then she was walking around with that bag. And that's what she was talking about. Yeah, it was,
How about these?
Yeah, those two. Yeah, she bought.
Is this yours too or no?
Yeah, that's ours. Yeah, she bought the toilet paper and the syringes.
So was that maybe $40 worth of stuff right there?
Yeah, she definitely bailed on. We found some stuff over that she didn't leave the store with. So she must have saw him and just immediately was like, okay, we'll put some of this stuff back. And then she bought like a few items to the register. It was like a data.
She was acting weird. We were watching her for like 20 minutes. I dealt with her.
Yeah.
She didn't break the skin or anything?
She did a little bit, but they
I would go get checked. You know what I mean? Like,
they were saying it wasn't.
your hand, not them. And, you know, she's a well-known prostitute.
3423.
'cause
How,
more
how
like-
well known?
She's advertises.
Oh, I was just asking how.
Is that right there?
Yeah.
That's broken skin, man.
Yeah.
Cool. You got everything to lose and nothing to gain, so might as well go. That is broken skin.
Yeah.
I'm sure I can handle the retail theft portion. Do a follow-up.
Yeah. Dude, why don't you do that and go straight to the hospital? Get that moving.
Do I got a quick follow-up?
Do you have a body cam, or is that an extra holder?
That's an extra holder.
Okay. It's for the best, man.
Yeah.
I mean,
Yeah.
get a tetanus shot, you know, at the very least, get a tetanus
They'll
shot.
give you a lollipop.
Alright. I do want to go with the PCS too.
Picture yourself stepping into a familiar retail store on an ordinary day. Bright lights, quiet aisles. A place designed for convenience, not danger. Nothing about this moment signals risk. Nothing suggests custody, charges, or jail exposure are minutes away. This is where most people believe the rules are simple. A small mistake stays small. A minor incident ends with a warning, maybe embarrassment, then everyone goes home. That belief feels safe. It feels logical. And it is exactly why what happens next catches so many people completely unprepared. Because in environments like this, outcomes are not decided by how ordinary the setting looks. They are decided by what happens when control is challenged. What begins as something that appears trivial does not stay that way. Within moments, the the situation crosses an invisible line, one most people never realize exists until it is already behind them. Handcuffs are no longer theoretical. Custody is no longer optional. Jail exposure is no longer exaggerated rhetoric. It becomes immediate, unavoidable, and irreversible. This is not a story about chaos. It is about predictability, about how the system responds when a routine moment turns into resistance, and about how quickly legal gravity asserts itself once certain actions occur. The most dangerous assumption is not that nothing will happen. It is believing you still have time after the point where the decision has already been made. The central legal question in this case is deceptively simple. When does a minor encounter lose its legal ceiling and become something far more serious without any warning from the system itself? Most people believe there is a buffer, a space where cooperation can be renegotiated, a moment where intentions still matter. That belief is the legal myth at the center of this incident. It assumes the law evaluates situations gradually, weighing context and second chances in real time. But the law does not operate on feelings or perceived fairness. It operates on thresholds. By the end of this video, you will understand why the thing she believed would protect her is exactly what made arrest inevitable. Because once a specific legal boundary is crossed, discretion collapses. The outcome stops being negotiable, and what felt like a minor situation instantly recalibrates into a charge-driven process with consequences that cannot be undone. The encounter begins inside a retail store, an environment governed by private property rules, surveillance, and routine loss prevention practices. Nothing about the setting suggests a criminal escalation. There is no public disturbance, no immediate threat, just a quiet space where authority exists, but remains largely invisible. What changes the trajectory is not suspicion alone, but movement. The moment an individual attempts to leave while under scrutiny, the situation shifts from observation to enforcement. Authority enters, not to punish, but to control uncertainty. At that point, the issue is no longer merchandise, it is compliance. From there, the timeline compresses rapidly. A brief interaction turns into pursuit. Distance replaces dialogue. Each step away removes options instead of creating them. What could have remained a contained encounter becomes mobile, unpredictable, and increasingly difficult to resolve peacefully. The critical detail is not speed or location. It is the narrowing of lawful alternatives. As physical distance increases, verbal control loses effectiveness. As resistance appears, authority becomes procedural rather than discretionary. By the time the situation leaves the store's boundaries, the original reason for attention no longer matters. The legal system is now responding to behavior in motion, not intent at rest, and the conditions for escalation are already in place. Everything changes here. Up to this point, the situation still exists within a reversible space. Movement can stop, compliance can resume, the legal outcome remains flexible. But that window closes the moment physical resistance enters the encounter. The instant bodily force is used to prevent control. The legal dynamic shifts. This is no longer about suspicion, investigation, or even flight. It becomes a question of whether authority can lawfully perform its function without interference. At that moment, intent becomes secondary. Impact becomes decisive. The law does not measure resistance by how long it lasts, or how successful it is. It measures whether physical action is used to obstruct a lawful duty. Once contact occurs, the state is no longer persuading, it is responding. This is where many people misunderstand the boundary. They believe resistance is only defined by weapons or injury. In reality, resistance is defined by opposition. Physical struggle alone is enough to elevate the encounter into a different legal category. The moment physical contact occurs, the legal system stops asking why and starts documenting what. Probable cause solidifies, discretion narrows. Charges begin to stack, not because the situation escalated emotionally, but because the law requires a different response once that line is crossed. From here forward, the outcome is driven by procedure, not negotiation. The legal core of this case turns on a single axis, when resistance becomes a felony, regardless of how minor the original situation appeared. The governing myth is simple: if no weapon is used and no serious injury occurs, the charge remains low level. That belief is incorrect. Under criminal law, resistance is not evaluated by outcome. It is evaluated by conduct. Specifically, whether physical force is used to obstruct an officer who is lawfully performing a duty. This is where the statute draws a hard line. Here is the threshold that matters. Physical opposition, not aggression, not intent to harm, not success. The moment a person uses their body to prevent lawful control, the encounter exits the realm of passive noncompliance and enters resisting with violence. This is where a misdemeanor framework collapses into felony exposure. This is where speech becomes conduct. Words, protests, pleas, or objections, even loud or hostile ones, remain protected expression. But once physical action replaces verbal objection, the analysis changes. The law no longer weighs explanation. It measures interference. This is where annoyance becomes obstruction. This is where X becomes Y. The statute does not require prolonged struggle. It does not require visible injury. It does not require a weapon. A brief physical act that impedes control is sufficient. Once that threshold is crossed, probable cause attaches automatically. From that point forward, officers are not deciding whether to escalate. The law has already escalated for them. This is where intent stops mattering. Many people assume that explaining their behavior afterward restores discretion. It does not. Explanation is not justification. Once the elements are met, lawful duty, physical opposition, interference, the charge stands independently of motive. This is where a second elevation occurs. When physical contact results in bodily harm, even minimal, the analysis shifts again. Battery on a law enforcement officer is not evaluated by severity, but by status and contact. The protected role of the officer elevates the charge. What would otherwise be a low-level offense becomes a high-exposure felony because of who was harmed, not how badly. This is where the system stops negotiating and starts documenting. And once documentation begins, outcomes follow structure, not sympathy. Two counter-narratives commonly appear in cases like this, and both collapse under objective legal review. The first is freedom of speech. The assumption is that verbal protest, refusal, or emotional reaction creates legal protection once a situation escalates. It does not. Speech remains protected only until it is replaced by conduct. The moment physical action is used to obstruct a lawful duty, constitutional protection ends. The law evaluates behavior, not tone or frustration. At that point, expression becomes legally irrelevant. The second narrative is police brutality. This claim often emerges after force is used to regain control, but legally, force is evaluated under an objective reasonableness standard, not hindsight. The question is not whether force looked excessive later, but whether it was reasonable at the moment resistance occurred. Once physical opposition is present, authority is permitted to respond proportionally to restore control. Neither narrative alters the core analysis. The law does not debate motives. It applies tests. And once those tests are met, the outcome is no longer negotiable. What emerges in encounters like this is not a medical condition, but a recurring behavioral pattern. It begins with authority, confusion, the belief that compliance is optional until consequences feel real. That belief is reinforced by entitlement, the assumption that personal urgency or perceived unfairness creates flexibility in enforcement. As pressure increases, this pattern often shifts into status insulation, where the individual treats the encounter as negotiable rather than procedural. When control is asserted, the response escalates into Darvo deny, attack, reverse victim and offender, reframing resistance as mistreatment. This is not a mental health diagnosis. This is a behavioral pattern. It appears when individuals misread legal boundaries as social boundaries. But the law does not respond to narratives. It responds to actions. And once conduct replaces dialogue, the pattern stops being psychological and becomes legal, triggering consequences that cannot be managed through perception alone. By the time the encounter reaches its conclusion, the outcome is no longer shaped by perception or intent. It is determined by charges. The legal process has already taken control. What began as a low-level retail matter now carries multiple layers of exposure. Arrest is no longer discretionary. Booking becomes mandatory. The case moves forward under statutes that attach serious consequences to physical resistance and unlawful contact with a protected official. Jail exposure is no longer hypothetical. Fines, probation, and long-term criminal records enter the equation not as punishment, but as prescribed outcomes under the law. This is how order is restored not through emotion, but through structure. The system does not escalate to teach a lesson. It escalates to reassert boundaries once they have been crossed. When lawful authority is physically obstructed, the response is not optional. It is procedural. Once bodily harm occurs, even minimally, the law responds based on role and status, not sympathy or explanation. At this stage, the narrative is finished. What remains is process. Court dates replace conversations, statutes replace assumptions, consequences replace negotiation. This is the part most people misunderstand. Order is not the absence of freedom. Order is what allows freedom to exist without collapsing into unpredictability. The law does not apply selectively, and it does not pause for reconsideration once its thresholds are met. Here, the outcome is no longer reversible. The system has spoken, and legal order is restored.